Hello. Today we are going to compare two examples of transitional justice. One, the South Africa after the apartheid, and the second, Colombia after the peace of agreement with the FARC. So our main question is how a country moved toward peace without forgetting the rights of the victims. And to answer this question, we will compare two things. First, truth and memory, and second, justice and responsibility. To begin with, we need to explain the meaning of transitional justice. According to the United Nations, transitional justice includes mechanisms such as trials, truth commission, reparations, and institutional reforms. In simple words, transitional justice is used when a country wants to deal with a violent past and build more peaceful future. So it is not only putting people in prison, it is also about listening to victims, explain what it happened, repairing the harm, and trying to make sure that the violence doesn't happen again. In the first case, that is South Africa, for many years South Africa lived under the apartheid. Apartheid was a legal system of racial segregation. Under this system, black people and other racial groups suffered discrimination, exclusion, and serious human rights violation. When apartheid ended, South Africa had a very difficult problem. The country needed peaceful and reconciliation. However, victims also need truth and justice. That's why South Africa created the Truth and Reconciliation Commission. According to the Truth and Reconciliation Commission report, the commission was created to investigate serious human rights violations during the apartheid period. The South African model gave an important place to truth. Victims could tell their stories in public. That was very important because many victims had been silent for many years. In other words, the commission gave victims a space to be heard and recognized by the country. However, this model was also criticized because some perpetrators could receive conditional amnesty. That means that some people could avoid prison if they told the full truth and showed their actions had political purposes. So South Africa gave truth a central role, but criminal punishment was more limited. This is one of the main criticisms of the South African model. Truth was very important, but for many victims it was not enough. Some victims wanted the people responsible to be punished in the court. From an international law perspective, this creates a tension. A state can use a special mechanism after violence, but it also has duties towards victims. Victims have rights to truth, justice, reparation, and guarantees of non-repetition. So South Africa is a strong example of truth reconciliation, but it is often criticized because criminal accountability was more limited. Now, the second case is Colombia. Colombia had an internal armed conflict for than 50 years. The conflict involved the state, the FARC, that is the guerrilla group, paramilitary groups, and other armed creators. In 2016, the Colombian government and the FARC signed the final peace agreement. According to the 2016 Colombian final peace agreement, the country created a comprehensive system of truth, justice, reparation, and non-repetition. This system includes three main institutions: the Truth Commission, the Unit Search Disappeared Person, and the Special Jurisdiction for Peace, known as the JEP. This is different in comparison to South Africa. Colombia did not rely only on a Truth Commission. Colombia created a border system that this system connects the trust, justice, reparation, and non-repetition. According to the official website of the Special Jurisdiction for Peace, the JEP is the justice component of transitional justice system. The JEP is important because it's not normal criminal court. It is a special tribunal created for crimes related to armed conflict. So the purpose of the JEP is not only to punish, it also seeks the truth, recognition of responsibility, and reparation for the victims. For example, if a person accepts responsibility and tells the truth, that person can receive a restorative sanction. That includes the restrictions of rights and works that help repair the harm caused to victims. On the other hand, if a person doesn't really accept the responsibility, the sanction can be more severe. So Colombia tried to encourage truth, but without completely abandoning justice. That's the difference between the both cases. In one case, South Africa focuses mainly on the truth reconciliation, and in contrast, Colombia tried to combine the truth with a special form of legal responsibility. However, Colombia also has problems. Some people think that the JEP sanctions are too soft for serious crimes. Other people argue that the reflexive sanctions were necessary to make the peace process possible. This shows the main dilemma of transitional justice. If punishment is too strong, peace may become harder, but if punishment is too weak, victims may feel that their rights were negotiated. To conclude my part, both countries had a similar problem, that is how to build a new stage after serious violence, but South Africa chose a model centered in the truth and reconciliation, and Colombia chose a center that is truth, justice, reparation, and guarantees of non-repetition. So now my partner will compare the two models in a critical way from the perspective of international law.
Well, thank you. The main idea of this comparison is that transitional justice is not a perfect justice. This is a type of justice created for very difficult moments, and however, this doesn't mean that states can ignore the victims. From that perspective of international law, victims also have rights, and these rights include truth, justice, reparation, and guarantees of non-repetition. Well, first we will compare truth in two different examples. In South Africa, the Truth and Reconciliation Commission allowed victims to speak publicly about what happened during the apartheid. And this was important because truth was not only information, truth was also recognition. And victims could say, this happened to me, and country must recognize it. Well, in Colombia, the Truth Commission had a similar purpose, but according to the Colombia Truth Commission, the final report seeks to clarify what happened during the armed conflict. So both countries ask truth as a well-reconstruction memory and recognize victims. However, there is an important difference, because in South Africa, truth was center of process, and in Colombia, truth was part of a board system, and that also includes justice, search for disappeared persons, reparations, and non-repetitions. For that reason, in Colombian model, can be seen as a more complete is an institutional design. But a good design is not enough if the system must also have work in real life. Colombia still faces challenge because many victims are still waiting for Congress results. And peace agreements and institutional are important, but they must produce real justice and real reparation. Second, we will compare justice. South Africa allowed conditional amnesties. Okay? This means that some perpetrators about criminals' punishment if they confess the full truth about their crimes. This can be as a political decision. This can be defended as a political decision. Maybe without amnesties, the transition from apartheid to democracy would have been more violent. But it can also be criticized because many victims did not receive criminal justice. Colombia followed a different path. Colombia created a special tribunal for the armed conflict. The GEP uses a restorative approach. This means that justice is not only about prison, it is also about truth, responsibility, and reparation of victims. This model doesn't not ignore the victims, and it creates legal consequences, even if these consequences are different from ordinary criminals' punishment. According to the United Nations, traditional justice includes mechanisms such as trials, truth, commission, reparation, and institutional reforms. This is important because international law allows flexibility of solutions, but it doesn't not support total impunity for seriously human rights violence. In simple words, a country can use special mechanisms, but it cannot simply say nothing happened and no one is responsible. This is why Colombia can be seen as a more balanced model in design. It gives benefits to people who tell the truth and accept responsibility. However, it also gives adjusting mechanisms. South Africa, on the other hand, have a very strong role to truth, but justice was more limited. For third point, we will compare reparation and non-repetition guarantees. In South Africa, one of the main criticisms was that reparations were not enough. Many victims received public recognition, but they did not always receive enough material reparations. This shows that truth commissions are important, but they cannot replace other forms of justice in South Africa. The model includes reparation and guarantees of non-repetition as a part of the system. And in other perspective, this is a strong theory, but again, the main challenge is implementation. If the state doesn't not fully apply the agreement, victims may continue without real answers. So, which model is better? There is not a simple answer, but countries had different historical context. So, South Africa was living a system of rational segregation, and Colombia was trying to end a long armed conflict. However, from an international law perspective, Colombia seems more complete exact design because it tries to include truth, justice, reparation, and non-repetition in only one system. South Africa was historically important because it showed the values of public truth, but its main weakness was limited by criminal accountability. In conclusion, South Africa and Colombia shows two different ways to dealing with a violent past. For one part, South Africa chose truth and reconciliation, and for other part, Colombia chose a broader model of combined truth, justice, and restorative responsibility. But that means like a country cannot build lasting peace by simple forgetting the past about these victims. And the real peace requires memory, recognition of victims, and responsibility and institutional change. Thank you.